Criminal Justice Chapter 1 Reading by Amaree M. The Nature, Purpose, and Function of Criminal Law. May the police officers be subjected to prosecution in both state and federal court. As videotape begins, it shows that King rose from the ground and charged toward Officer Powell. Powell took a step and used his baton to strike King on the side of his head. King fell to the ground from the 18th to the 30th second on the videotape. King attempted to rise, but Powell and Wynn each struck him with their batons to prevent him from doing so. From the 35th to the 51st second, Powell administered repeated blows to King's lower extremities. One of the blows fractured King's legs. At the 55th second, Powell struck King on the chest, and King rolled over and lay prone. At that point, the officer stepped back and observed King for about 10 seconds. At 1 minute 5 seconds on the videotape, Briseno in the district court's words stomped on King's upper back or neck. King's body writhed in response. At 1:07, Powell and Wynn again began to strike King with a series of baton blows, and Wynn kicked him in the upper thorax and cervical area 6 times until 1:26. At about 1:29, King put his hands behind his back and was handcuffed. The introduction. Criminal law is the foundation of the criminal justice system. The law defines the conduct that may lead to an arrest by the police, trial before the court, and incarceration in prison. When we think about criminal law, we typically focus on offenses such as rape, robbery, and murder. States, however, condemn a range of acts in their criminal codes, some of which may surprise you. In Alabama, it is a criminal offense to promote or engage in a wrestling match with a bear, or to train a bear to fight in such a match. A Florida law states that it is unlawful to possess any ignited tobacco product in an elevator. Rhode Island declares that individuals shall be in prison for 7 years who voluntarily engages with a dual and dangerous weapon, or who challenges an individual to a duel. In Wyoming, you can be arrested for skiing while being impaired by alcohol, or for opening and failing to close a gate in a fence that crosses private road or river. You can find criminal laws on the books in various states punishing activities such as playing dominoes on Sunday, feeding alcoholic beverage to a moose, cursing on a miniature golf course, making love in a car, or performing a wedding ceremony when either the bride or groom is drunk. In Louisiana, you risk being sentenced to 10 years in prison for stealing an alligator, whether dead or alive, valued at $1,000. The nature of criminal law. Are there common characteristics of acts that are labeled as crime? How do we define a crime? The easy answer is that a crime is whatever the law declares to be a criminal offense and punishes with a penalty. The difficulty with this approach is that not all criminal convictions result in fine or imprisonment. Rather than punishing a defendant, the judge may merely warn him or her not to repeat the criminal act. Most commentators stress that the important feature of a crime is that it is an act officially condemned by the community and carries a sense of shame and humiliation. Professor Henry M. Hart Jr. defines crime as conduct which, if shown to have taken place, will result in the formal and solemn pronouncement of the moral condemnation of the community. The central point of Professor Hart's definition is that a crime is subject to formal condemnation by a judge and jury representing the people in a court of law. This distinguishes a crime from acts most people would find objectionable that typically are not subject to state prosecution and official punishment. We might, for instance, criticize someone who cheats on his or her spouse, but we generally leave the solution for the individuals to be solved. Other matters are left to institutions to settle, but schools generally discipline students who cheat or disrupt class, but this rarely results in a criminal charge. Professional baseball, basketball, and football leagues have their own private procedures for disciplining players. Most states leave the decision whether to recycle trash to the individual and look to peer pressure to enforce this obligation. Criminal and civil law. How does the criminal law differ from civil law? Civil law is that branch of law that protects the individual rather than the public interest. A legal action for a civil wrong is brought by an individual rather than by a state prosecutor. You may sue a mechanic who breaches a contract to repair your car, or bring an action against a landlord who fails to adequately heat up your apartment. The injury is primarily to you as an individual, and there is relatively little harm to society. A mechanic who intentionally misleads and harms a number of innocent consumers, however, may find himself or herself charged with a criminal fraud. Civil and criminal actions are characterized by different legal procedures. For instance, conviction of a crime requires a high standard of proof beyond reasonable doubt, although responsibility for a civil wrong is established by the much lower standard of proof by preponderance that of the evidence of roughly 51% certainty. The high standard of proof in criminal cases reflects the fact that a criminal conviction may result in a loss of liberty and significant damage to an individual's reputation and standing in the community. The famous 18th century English jurist William Blackstone summarizes the distinction between civil and criminal law by observing that civil injuries are infringement of the public rights and duties due to the whole community of the civil rights, which begins individuals' public wrongs or crimes are a breach or violation of the public rights and duties due to the whole community. In its social aggregate capacity, Blackstone illustrates this difference by pointing out that society has little interest in whether someone sues a neighbor or emerges victorious in a land dispute. On the other hand, society has a substantial investment in the arrest, prosecution, and conviction of individuals responsible for espionage, murder, and robbery. The difference between a civil and criminal action is not always clear, particularly with regard to an action for tort, which is an injury to a person or his or her property. Consider the drunken driver who runs a red light and hits your car. The driver may be sued in tort for negligently damaging you and your property, as well as criminally prosecuted for reckless driving. The purpose of the civil action is to compensate you with money for the damage for your car and for the physical and emotional injuries you have suffered. In contrast, the criminal action punishes the driver for endangering society. Civil liability is based on a preponderance of evidence standard, while a criminal conviction carries a possible loss of liberty and is based on a higher standard of guilt beyond a reasonable doubt. You may recall that former football star O.J. Simpson was acquitted of murdering Nicole Brown Simpson, and Ron Goldman was later found guilty of wrongful death in a civil court in order to compensate the victim's family in the amount of $33.5 million. The distinction between criminal and civil law provided immensely significant for Kansas inmate Leroy Hendricks. Hendricks was about to release after serving 10 years in prison for molesting two 13-year-old boys. This was only the latest episode in Hendricks' almost 30-year history of indecent exposure and molestation of young children. Hendricks freely conceded that when not confined, the only way to control his sexual urge was to die. Upon learning that Hendricks was about to be released, Kansas authorities invoked the Sexually Violent Predator Act of 1994, which authorized the institutional confinement of individuals due to a mental abnormality or a personality disorder are likely to engage in predatory acts of sexual violence. Following a hearing, a jury found Hendricks to be a sexual predator. The U.S. Supreme Court ruled that Hendricks' continued commitment was a civil rather than a criminal penalty, and that Hendricks was not being unconstitutionally punished twice for the same criminal act of molestation. The court explained that the purpose of the commitment procedure was to detain and treat Hendricks in order to prevent him from harming others in the future rather than to punish him. Do you think that the decision of the U.S. Supreme Court makes sense? The purpose of criminal law. We have seen that criminal law primarily protects the interests of society and civil law protects the interests of the individual. The primary purpose or function of criminal law is to help maintain social order and stability. The Texas Criminal Code proclaims that the purpose of criminal law is to establish a system of prohibitions, penalties, and correctional measures to deal with conduct that unjustifiably and inexcusably causes or threatens harm to those individual or public interests for which state protection is appropriate. The New York Criminal Code sets out the basic purpose of criminal laws as follows. Harm: to prohibit conduct that unjustifiably or inexcusably causes or threatens substantial harm to individuals as well as to society. Warning: to warn people both of conduct that is subject to criminal punishment and of the severity of the punishment. Definition: to define the act and intent that is required for each offense. Seriousness: to distinguish between serious and minor offenses and to assign the appropriate punishment. Punishment: to impose punishments that satisfy the demands for revenge, rehabilitation, and deterrence of future crimes. Victims: to ensure that the victim's family, and the community interests are represented at trial and imprisoning punishment. The next step is to understand the characteristics of the criminal act. The principles of criminal law. The study of substantive criminal law involves an analysis of the definition of specific crimes, specific part, and of the general principles that apply to all crimes, general part, such as the defense of insanity. In our study, we will first review the general part of criminal law and then look at the specific offenses. Substantive criminal law is distinguished from criminal procedure. Criminal procedure involves a study of legal standards governing the detection, investigation, and prosecution of crime and includes areas such as interrogation, search and seizure, wiretapping, and the trial process. Criminal procedure is concerned with how the law is enforced. Criminal law involves what law is enforced. Professors Jerome Hall and Wayne R. Lefebvre identified the basic principles that compose the general part of the criminal law. Think of the general part of the criminal law as the building blocks that are used to construct specific offenses such as rape, murder, and robbery. Criminal act: a crime that involves an act or failure to act. You cannot be punished for bad thoughts. A criminal act is called actus reus. Criminal intent: a crime requires a criminal intent or mens reus. Criminal punishment is ordinarily directed at individuals who intentionally, knowingly, recklessly, or neglectfully harm others, individuals, or property. Concurrence: the criminal act and criminal intent must coexist or accompany one another. Causation: the defendant's act must cause harm required for criminal guilt, death in the case of homicide, and the burning of a home or other structure in the case of arson. Responsibility: individuals must receive reasonable notice of the acts that are criminal so as to make a decision to obey or to violate the law. In other words, the required criminal act and criminal intent must be clearly stated in statute. This concept is captured by the Latin phrase nullum crimen sine lege, nulla poena sine lege. No crime without law, no punishment without law. Defenses: criminal guilt is not imposed on an individual who is able to demonstrate that his or her criminal act is justified, benefits society, or excuse the individual suffered from a disability that prevented him or her from forming a criminal intent. We now turn to a specific part of the criminal law to understand the types of acts that are punished as crime. Categories of crime: felonies and misdemeanors. There are a number of approaches to categorizing crimes. The most significant distinction between a felony and a misdemeanor: a crime punishable by death or in prison for more than 1 year is a felony. Misdemeanors are crimes that are punishable by less than a year in prison. Note that whether a conviction is for a felony or a misdemeanor is determined by the punishment provided in the statute under which an individual was convicted rather than by the actual punishment imposed. Many states subdivide felonies and misdemeanors into several classes or degrees to distinguish between the seriousness of criminal acts. Capital felonies are crimes subject either to the death penalty or to life in prison in states that do not have the death penalty. The term gross misdemeanor is used in some states to refer crimes subject to between 6 and 12 months in prison, whereas the other misdemeanors are termed petty misdemeanors. Several states designate a third category of crimes that are termed violations or infractions. These tend to be acts that cause only modest social harm and carry fines. These offenses are considered so minor that imprisonment is prohibited. These includes the violation of traffic regulations. Florida classifies offenses as felonies, misdemeanors, or non-criminal violations. Non-criminal violations are primarily punishable by a fine or forfeiture of property. The following list shows the categories of felonies and misdemeanors and the maximum punishment generally allowable under Florida law. Capital felony: death, life, or imprisonment without parole. Life felony: life in prison and a $15,000 fine. Felony in the first degree: 30 years in prison and a $10,000 fine. Felony in the second degree: 15 years in prison and a $10,000 fine. Felony in third degree, 5 years in prison and a $5,000 fine. Misdemeanor in first degree, 1 year in prison and a $1,000 fine. Misdemeanor in second degree, 60 days in prison and a $500 fine. The severity of the punishment imposed is based on the seriousness of the particular offense. Florida, for example, punishes a second-degree felony the recruitment of individual for prostitution, knowing that force, fraud, and coercion will be used to cause the person to engage in prostitution. The same act is punished as a first-degree felony in the event that the person recruited under 14 years old or if death results. Mala en se y mala prohibita. Another approach is to classify crime by moral turpitude, which is evil. Mala en se crimes are considered inherently evil and will be evil even if you're not prohibited by the law. This includes murder, rape, robbery, burglary, larceny, and arson. Mala prohibita offenses are not inherently evil and are considered only wrong because they are prohibited by a statute. This includes offenses ranging from attack, evasion, carrying a concealed weapon, leaving the scene of an accident, being drunk and disorderly in public. Why should we be concerned with the classification schemes? A felony conviction can prevent you from being licensed to practice various professions, bar you from being admitted to the armed forces or joining the police, and prevent you from adopting a child or receiving various forms of federal assistance. In some states, a convicted felon is still prohibited from voting, even following release. The distinction between mala en se and mala prohibida is also important. For instance, the law provides that individuals convicted of a crime of moral turpitude may be deported from the United States. There are a number of other classification schemes the law originally categorized as infamous, those crimes that were considered to be deserving of shame or disgrace. Individuals convicted of infamous offenses such as treason, betrayal of a nation, or offenses involving dishonesty were historically prohibited from appearing at witness trials. Subject matter. Subject matter. This textbook is organized in accordance with the subject matter of crimes, the scheme that is followed in most state criminal codes. There is disagreement, however, concerning the classification of some crimes. Robbery, for instance, involves the theft of property as well as the threat or infliction of harm to the victim, and there is a debate about whether it should be considered a crime against property or against the person. Similar issues arise in regard to burglary. Subject matter offenses in descending order of seriousness are as follows. Crime against the state, treason, sedition, espionage, terrorism, Chapter 16, crime against the person, homicide, murder, manslaughter, Chapter 10, crimes against the person, sexual offenses and other crimes, rape, assault, battery, false imprisonment, kidnapping, Chapter 11, crimes against habitation, burglary, arson, trespassing, Chapter 12, crimes against property, larceny, embezzlement, false pretenses, receiving stolen property, robbery, fraud, Chapters 13 and 14, crimes against public order, disorderly conduct, riot, Chapter 15, crimes against the administration of justice, obstruction of justice, perjury, robbery, Chapters 14 and 15, crimes against public morals, prostitution, obscenity, Chapter 15. The book also covers the general part of criminal law, including the constitutional limits on criminal law, Chapter 2, sentencing, Chapter 3, criminal acts, Chapter 4, criminal intent, Chapter 5, the scope of criminal liability, Chapter 6 and 7, and defenses to criminal liability, Chapters 8 and 9. Sources of criminal law. We now have covered the various categories of criminal law. The next question to consider are these. What are the sources of criminal law? How do we find the requirements of criminal law? There are a number of sources of criminal law in the United States. English and American common law. These are English and American judge-made laws and are English acts of parliament. State criminal codes. Every state has a comprehensive set of laws in crime and punishment. Municipal ordinances. Cities, towns, and counties typically authorized to enact local criminal laws, generally minor in nature. These laws regulate the city streets, sidewalks, and buildings in concerned areas such as traffic, littering, disorderly conduct, and domestic animals. Federal Criminal Code. The U.S. government has jurisdiction to enact criminal laws that are based on the federal government's constitutional powers, such as regulation of the interstate commerce. State and federal constitution. The U.S. Constitution defines treason and together with the state constitution establish limits on the powers of government to enact criminal laws. A criminal statute, for instance, may not interfere with the freedom of expression or religion. International treaties. International treaties signed by the United States establish crimes such as genocide, torture, and war crimes. These treaties, in turn, form the basis of federal criminal laws punishing the acts such as genocide and war crimes. When Americans are involved, these cases are prosecuted in the U.S. courts. Judicial decisions. Judges write decisions explaining the meaning of criminal laws and determining whether criminal laws meet the requirements of state and federal constitution. Judges typically rely on precedent or the decision of other courts in similar cases. At this point, we turn our attention to the common law origins of American criminal law and to state criminal codes. The common law. The English common law is the foundation of American criminal law. The origins of common law can be traced to Norman conquest of England in 1066. The Norman king William the Conqueror was determined to provide a uniform law for England and sent royal judges throughout the country to settle disputes in accordance with the common customs and practices of the country. The principles that compose this common law began to be written down in 1300 in an effort to record the judge-made rules that should be used to decide future cases. By 1600, a number of common law crimes had been developed, including arson, burglary, larceny, manslaughter, mayhem, rape, robbery, sodomy, and suicide. These were followed by criminal attempt, conspiracy, blasphemy, forgery, sedition, and solicitation. On occasion, the king and the Parliament issued a decree that filled the gaps in the common law, resulting in the development of crimes of false pretense and embezzlement. This distinctive characteristic of the common law is that it is, for the most part, the product of decisions of judges in actual cases. The English civil and criminal common law was transported to new American colonies and formed the foundation of the colonial legal system that was in turn adopted by the 13 original states following the American Revolution. The English common law was also recognized by each state subsequently admitted to the Union. The only exception was Louisiana, which followed the French Napoleonic Code until 1805 when it embraced the common law. State criminal codes. States in the 19th century began to adopt comprehensive written criminal codes. This movement was based on the belief that in a democracy, the people should have the opportunity to know the law. Judges in the common law occasionally punish an individual for an act that had never before been subjected to prosecution. A defendant in Pennsylvania case was convicted of making obscene phone calls despite the absence of previous prosecution for this offense. The court explained that the common law is sufficiently broad to punish, although there may be no exact precedent any act which directly injures or tends to injure the public. There was the additional argument that the power to make laws should reside in the elected legislative representatives of the people rather than in unelected judges. As Americans began to express a sense of independence, there was also a strong reaction against being so clearly connected to English common law tradition, which was thought to have limited relevance to the challenges facing America. As early as 1812, the U.S. Supreme Court proclaimed that federal courts were required to follow the law established by Congress and were not authorized to apply the common law. States were somewhat slower than the federal government to abandon the common law. In Maine a case in 1821, the accused was found guilty of dropping the dead body of a child into a river. The defendant was convicted even though there was no statute making this as a crime. The court explained that with good morals and decency all forbid this act. State legislators reacted against these types of decisions and began to abandon the common law in the mid-19th century. The Indiana Revised Statutes of 1852, for example, proclaimed that crimes and misdemeanors shall be defined in punishment fixed by statutes of the state and not otherwise. Some states remain common law states, meaning that the common law may be applied where the state legislature has not adopted law in a particular area. The Florida Criminal Code states that the common law of England in relation to crimes, except so far as the same relates to the mode and degrees of punishment, shall be of full force in the state where there is no existing provision by statute on the subject. Florida law further provides that where there is no statute, the offense shall be punished by fine or imprisonment, but that fine shall not exceed 500, nor the term of imprisonment 12 months. Missouri and Arizona are also examples of common law states. These states' criminal codes, like that Florida, contain reception statute that provides the states receive the common law as an unwritten part of their criminal law. California, on the other hand, is a symbol of code jurisdiction. The California Criminal Code provides the no act or omission is criminal or punishable except as prescribed or authorized by this code. Ohio and Utah are also code jurisdiction states. The Utah Criminal Code states that common law crimes are abolished No conduct is a crime unless made so by this code or ordinance. Professor Lefebvre observes that courts and common law states have recognized a number of crimes that are not a part of their criminal codes, including conspiracy, attempt, solicitation, uttering gross obscenities in public, keeping a house of prostitution, cruelly killing a horse, public inebriation, and false imprisonment. You also have to keep in mind the common law continues to play a role in the law of code jurisdiction states. Most state statutes are based on the common law, and courts frequently consult the common law to determine the meaning of terms and statutes. In the well-known California case of Keeler versus Superior Court, the California Supreme Court looked to the common law and determined that an 1850 state law prohibiting the killing of a human being did not cover the murder of a fetus. The California state legislature then amended the murder state to punish the unlawful killing of a human being or a fetus. Most important, our entire approach to criminal trials reflects the common law's commitment to protecting the rights of an individual, criminal justice power, state police power. Are there limits on a state's authority to pass criminal law? Could a state declare that it's a crime to possess fireworks on July 4th? State government possess the broad power to promote the public health, safety, and welfare of the residents of the state. This wide-ranging police power includes the duty to protect the well-being and tranquility of the community and to prohibit acts or things reasonably thought to bring evil or harm to its people. An example of the FAR acts An example of the far-reaching nature of the state police power is the U.S. Supreme Court's upholding of the right of a village to prohibit more than two unrelated people from occupying a single home. The Supreme Court proclaimed that the police power includes the right to lay out zones where family values, youth values, the blessing, quiet seclusion, and clean air make an area for sanctuary for people. State legislators in formatting code, the content of criminal codes have been profoundly influenced by model penal code. The Model Penal Code. People from other countries often ask how students can study the criminal laws of the United States, a country with 50 states and the federal government. The fact that there is a significant degree of agreement in the definition of crimes in state codes is due to a large extent of the Model Penal Code. In 1962, the American Law ALI, a private group of lawyers, judges, and scholars, concluded after several years of study that despite our common law heritage, state criminal statutes radically varied in their definition of crimes and were difficult to understand and poorly organized. The ally argued that the quality of justice should not depend on the state which individual was facing trial and issued a multi-volume set of model criminal laws. The proposed official draft of the Model Penal Code. The Model Penal Code is a purely advisory and is intended to encourage all 50 states to adopt a single uniform approach to criminal law. The statutes are accompanied by a commentary that explains how the penal code differs from the existing state statutes. Roughly 37 states have adopted some of the provisions of the Model Penal Code. Although no state has adopted every single model law, the state that most closely follows the code are New Jersey, New York, Pennsylvania, and Oregon. As you read this book, you may find it interesting to compare the Model Penal Code to the common law and others and to state statutes. This book primarily discusses criminal law. It is important to remember that we also have a federal system of criminal law in the United States. Federal statutes. The United States has a federal system of government. The states granted various powers to the federal government that are set forth in the U.S. Constitution. This includes the power to regulate interstate commerce, to declare war, to provide for the national defense, to coin money, to collect taxes, to operate the post office, and to regulate immigration. The Congress is entitled to make all laws which shall be necessary and proper for fulfilling these responsibilities. The states retain those powers that are not specifically granted to the federal government. The 10th Amendment to the Constitution states that the power is not delegated to the United States by the Constitution, nor prohibited by the states, are reserved to the states respectively, or to the people. The Constitution specifically authorizes Congress to punish the counterfeiting of the U.S. currency, piracy, and felonies committed on the high seas and crimes against the laws of the nation, as well as to make rules concerning the conduct of welfare. These criminal provisions are to be enforced by a single Supreme Court and by additional courts established by Congress. The Federal Criminal Code complies the criminal laws adopted by the U.S. Congress. This includes law-punishing acts such as tax evasion, mail immigration fraud, bribery in obtaining a government contract, and the knowing manufacture of defective military equipment. The Supremacy Clause of the U.S. Constitution provides that federal law is superior to a state law within those areas are the preserve of the national government. This is termed to be the preemption doctrine. In 2012, the Supreme Court held that federal immigration law that preempted several sections of Arizona statute directing undocumented individuals. Several recent court decisions have held that federal criminal law unconstitutionally encroached on areas reserved for state governments. This reflects a trend toward limiting the federal power to enact criminal laws. For instance, the U.S. government, with Interstate Commerce Clause, has interrupted its power to regulate interstate commerce as providing the authority to criminally punish harmful acts that involve the movement of goods